Hello and welcome to another episode of the IMG Roadmap podcast. I'm Dr. Nina Loom, and today we will be debunking this $100,000 fine fee rule that was proposed by the current administration on H-1B workers, particularly those filing after September 25. So this is for new applicants, not those in progress, not those who are already present in the United States. There's some exemptions even for F1 visa holders and other visa holders that are already present in the United States. This rule specifically states that a $100,000 fee will be required of H-1B applications that are coming into the Department of Homeland Security and the USCIS for every applicant after September 2025, new applicant. Apparently, in reading through the DHS's website, February 2026 is the official start date, so that it would carry through to the fiscal year for 27. So I want to talk about how this would affect physicians, how it could affect us, or if it would. So as you may know, I am a physician of foreign origin, originally from Cameroon in West Africa. Moved to the United States on an F1 visa, started out in Kaplan, and did a 6 weeks Kaplan course on an F1 visa, took step 1, and then I self-converted to a B1, B2 visa to be able to take my examinations while still present in the United States. So I did the USMLE step 1 while here, and I was able to also complete my clinical rotations or my US clinical experiences on that same B1, B2 status in the United States at the same time, simultaneously with working on my examination. So in the process there, I was so blessed and fortunate to apply into residency in family medicine, obtain two interviews for residency under the premise of a J1 visa. So I was applying as a J1 or potential J1 applicant while still on the B1, B2 visa, and then converted on to do my interviews, complete my interviews, left the United States and back home. I was in Cameroon when the results of the match came out. This was in 2012. So same time 2020, in 2012, in February, I was at home, shaking in my boots and not sure what was going to happen. The match results came out in March as usual, and I matched into my top program. However, that started the process for my J1 applications and the process of a J1, the DS 2019, obtaining that. Segue into coming back into the United States in June of 2012 and starting residency, completed 3 years of family medicine residency, applied for a waiver in my second year of residency, obtained that waiver by the end of second year, or by the start of third year, and then at the end of my third year of residency, converted into an H-1B visa to be able to work in the United States. I worked in a health professional shortage area in Laurel County, Kentucky, where it is listed that the physician to patient ratio there is as low as one primary care physician for 2,500 patients. So I know a thing or two about being an H-1B visa holder. And this video is just to go over what I think I would have done or I would be doing, okay, if I was in a situation now having to start a new H-1B application, knowing that there's a $100,000 fee on their line, which could really come in the way of an employer giving me a job. So the first thing I would do would be to familiarize myself with the actual rules and not to go with hearsay, because it's so easy to get bogged down by social media that you don't really read the documents on your own, and then you are all up in arms and confused and over. So my first reference would be the USCIS's website, and they have a specific page that I'm going to link in the show notes where it goes into detail on the presidential proclamation on restriction on entry of certain non-immigrant workers. First thing I should say is this rule, if you really read the details of it, was specifically honing in on tech. They didn't say much about healthcare directly, but it was tech. However, what I like is that there is an exemption in here, okay? They have a section that says who is subject to the $100,000 payment. So H-1B filed after 12 midnight or 12 daylight time. Yeah, 12 midnight, September 21st, 25. Okay, so from now on, how to pay the payment, they have a link to pay.gov where the employer will pay the payment on there, or the petitioner will pay the payment. And then when to pay it, it must be paid prior to the filing with the USCIS for the H-1B approval. Now, the exemption in that same document says, and I read verbatim, is that they will exempt extraordinarily rare circumstances where the Secretary of the Department of Homeland Security will determine that the particular alien worker's presence in the United States as an H-1B worker is in the national interest. That's the first criteria for exception. And I would tell you right now, physicians can prove national interest because physicians in in specialties where there's high shortages, FM, IM, EM, OB, psych, peds, can prove a shortage. I just told you I worked in Laurel County where there was one physician for about 2,600 according to Google's statistics from the Department of HHS. So if you can find an area where there's a shortage in health professionals, you may be able to prove national interest. That's my take. I'm not a legal counselor. I'm not a political commentator. I don't work for the government. I don't work for... These opinions and views are mine and mine alone. They do not reflect my employer. They do not reflect my prior employer. They do not reflect anybody. They reflect my opinion. So just take it with a grain of salt. But I think physicians can prove national interest. The second criteria is that no American worker is available to fill the role. Now, this is where the rubber meets the road, because there are obviously tons of U.S. graduates coming out of medical school here, and they can probably fill some of these roles as well. The question is how many U.S. graduates are actually pursuing some of these primary care specialties. And I speak for primary care because I'm a primary care trained physician. But I would think that even general surgery can prove this, because where I worked, I remember we had just a handful of general surgeons, about 2 or 3 of them. But there was still a shortage of physicians. And even the general surgeons at my facility one of them was Canadian, of Canadian origin, so they also had a J1. Or was it 2? Well, one of them was Canadian, one was American, and 2 were American, of the 3 that I mentioned. So you can still prove that even if you're in a surgical specialty, provided you find the geography that has the need. And one thing I remember with my H-1B application was the employer had to have listed that position and prove that no American who could fill the role. And they listed it in the local papers, and they had to include that paper publication in my H-1B application. So you need to have an attorney who really understands the process and knows exactly what they need to present. So assuming there's no American worker that's interested in your family medicine position, then you must also not pose a threat to the security of the United States. So the individual, so me, I need to be able to not have any reason for the government to think that I pose a threat to the United States. So that would be obviously not breaking any rules, or like overstaying a visa, or committing a crime, even a misdemeanor, nothing, right? Keep a clean record. I mean, at this point, even traffic violations, I'll try not to have anything on my record if I can. And then obviously national security, which is more along the lines of your affiliations and groups that you're affiliated with in your home country. Probably don't want to be a terrorist. Like, you don't want to do that, right? Like, let's not do that, okay? So you want to prove that you are not a threat. And then the requiring petitioning employer will make the payment on the alien's behalf, and that the requiring petitioning employer to make the payment on the alien's behalf will significantly undermine the interests of the United States. That part, I don't quite understand. So I'm not going to try to explain it. But talk to an attorney about that. What does that mean for you? However, I'm thinking national interest waivers. I'm just going to hone in on that because I did an episode on the IMG Roadmap podcast with Dr. Clarice Talat. This was back during the pandemic. And we published this episode because she was able to file and show national interest in her application. And I think if I remember right, she did it on her own. It's only a 35-minute podcast episode. It's episode number 13, published 3/28/2020. 35 minutes on the IMG Roadmap podcast. I'll include a graphic right here so you can go and find this episode and listen to it. But she detailed how she pursued a national interest waiver on her own in order to keep herself in the United States working. And I think she did it twofold. She's a physician and a researcher. So she both had interest for being able to put out publications and research in the Department of Maternal Health, and also as a family medicine physician. She was also OB fellowship trained family medicine. Great episode. I think you need to listen to it. But when you look at, if you leave from there and you go into the USCIS, and I'll also link the USCIS website down here, which has the specific requirements for proving national interest. They have eligibility criteria for proving national interest. Your endeavor has to have substantial merit, which research I think is a great angle for substantial merit, and of national importance. So you're trying to cure certain diseases, which will be of national importance, obvious. And, or the work that you were doing is positioned as expert level, advanced degree. So physicians and the rest of us, researchers, scientists, I think, possess the education, the skills, the knowledge, and a record of success, right? To be able to prove national interest, especially if we're on a J1 right now and are going to switch to an H-1B. So in residence, something that I would be doing is trying to get some publications out, because that would really show my ability and expertise, change the landscape for whatever condition or specialty that I'm looking at. So you need to also show evidence that you're well positioned to advance your endeavor. So evidence that I'm well positioned to advance research or family medicine or emergency medicine. I need to show that what I work with or work within will be beneficial to the United States, to waive the job offer. And they have additional evidence requirements on there. So again, please read this on your own. I'll tell you this, when I was in a medical student and I was living here on a B1, B2, I had to do all these extensions on my B1, B2 status. I did them on my own. I could not afford a lawyer. But the reason I was able to do those things on my own was because I spent time reading the USHS's guidelines, and I will go with it verbatim. So I think there's a lot to be said about doing your own research and knowing the rules for yourself. But looking back, I know I've said a lot, but let's reflect. What can you do as a future H-1B applicant? One, I'll keep looking for jobs, because there may be employers who are willing to pay the $100,000 fee. $100,000. Two, I would begin to seek out how I could qualify for an exception $1,000 fee by proving national interest with my research work, with my clinical. Three, I'll start searching for health physician shortage areas where the need for physicians is so high, and see if I can meet that need. And obviously you have no control, we have no control over if an American could get the position or not, but I'm sure that the employer is reviewing applications from more than just you. So that's up to them. But if it's within my power, I will hire an attorney if I can afford it to help me define my national interest and possibly see if I could qualify for a national interest waiver. That's what I would be doing right now if I was in your position. And then I will stay clear of social media and the opinions of people who are not legal experts, who are fearmongers and trying to deter you from thinking clearly about what you need to be focused on. And if you find that this video is one of those people, just delete and keep moving forward. You don't have to listen to the whole podcast. But I want you to have a voice of reason, which says that there are exceptions to the rule. It doesn't apply to those who have already had H-1B, so you can calm down if you already have an H-1B. But if you're yet to apply, that's who it may affect. I want you to begin to speak to attorneys about how can you get national interest on your behalf, behind your pocket. How can you prove that? And if you are needing an immigration attorney, I know one. I would give you a disclaimer. I have a sibling that is an immigration attorney. You don't have to work with them, but if you're interested in knowing where their firm is, I'll be happy to share that information. But I want you to focus on how can I prove exemption. That's what it is. Exemptions for the $100,000 fee will be processed, and you must have extraordinarily rare circumstances. So be thinking about how you can prove that. And I think the easiest way for is by proving national interest. So let me refer you to this episode number 13 of the IMG Road Map podcast, where we actually talked to who was able to prove national interest even before it became as popular as it is now. And I know people have been doing this before, but this would be a great way to guide you. If this episode is helpful for you, please subscribe, follow this page, and give us a thumbs up down below and chime in the comments, right? What are you seeing? What are you hearing? What's out there that's bothering you? I have seen some information around the internet about lawsuits being filed against the current administration regarding this $100,000 rule. We'll see where those take us, but I, as a foreigner, never felt confident enough to file a lawsuit against anybody, because I don't even feel like, I'm like, my voice doesn't count. When I live in someone else's country, I feel like I'm subject to their rules and their regulations, and And I'm more of that kind of person who would just stick to the rules. I'll do what you tell me to do and I'll stick to them. And so sometimes it's really hard for me to encourage people to take legal action against an administration. Like, I would never do that. That's not me, because that's just not me. Like, that's not my flavor. But, you know, now I'm a US citizen, so maybe I can talk to my senator. I guess that would be something I can do, because I have done that before. When I think about it, I did that when I was in Kentucky. I went over to DC with the, I went to DC with Society of Hospital Medicine, and we went to appeal for this cap to be removed from physicians of certain countries who had caps on their processing to green cards. So H-1B physicians from India, for example, they had long wait times to get green cards. And the Department of the Society of Hospital Medicine, we lobbied on Capitol Hill, and I'll try to find those photos and include them up here. I remember going to Mitch McConnell's office, the senator for Kentucky, where I worked and lived, and going to Representative Hall Rogers' office, and I actually got to meet him, and he was very welcoming to why I was in Capitol Hill that day, and he thanked me for my work in Kentucky at the time, and we took a picture together that I'm going to include up here. But so yes, maybe speaking to my senator is something I can to just help shed light on the importance of physicians, especially primary care physicians in rural settings, and how that is of national interest to the United States. And yeah, so I want you guys to take home these 4 things. Find exemptions: that you are, 1, a worker of national interest, there's no American available to fill your role, and you do not possess a personal threat to the security of the United States, and that the employer, so your hospital, making the payment on your behalf would significantly undermine the interests of the United States. If the hospital can prove that, then you may be able to qualify for an exception if you have an extraordinary rare circumstance. So share this video with an H-1B aspirant, applicant, future applicant, and let me know what you think. What did I live out? Where did I make a mistake? What did I misunderstand? Let me know in the comments. I'll see you in the next video. Bye for now.